is Shrees. I'm an attorney at the Shrees Law Group, and joining me today is Mr. Brian Block, who is also an attorney at my firm. We're here today to talk to you about reckless driving and what it means to get a reckless driving ticket in the state of Virginia. I'm a former prosecutor, and Mr. Block is a former state trooper. When you get a reckless driving ticket, whether you're an out-of-state driver or an in-state driver, what most people don't realize is that it is a criminal charge. It is not a simple speeding ticket, it is not a simple traffic violation, but it is a criminal charge. And how you handle that charge can have a huge impact on your driving license, your points, and your insurance rates. On top of which, if you are convicted of reckless driving, it is a criminal charge and it is a Class 1 misdemeanor, the highest misdemeanor possible in the state of Virginia. Therefore, if you have been charged with reckless driving, the very first thing you need to do is seriously consider getting an attorney. Mr. Block is now going to talk to you briefly about the two types of reckless driving tickets we see most often in our firm. Mr. Block?
The first kind we defend against most commonly is reckless driving by speed. And this is an allegation that the defendant has exceeded the speed limit by 20 more miles per hour or exceeded 80 miles per hour regardless of the posted speed limit. This is kind of an enhanced speeding charge, but it is a Class 1 misdemeanor which carries up to a $2,500 fine and 1 year in jail. Although judges don't typically sentence people to jail unless they've exceeded 30 miles per hour over the speed limit. Very often we defend people who have been charged with very high speeds and are exposed to jail time and loss of their license and some severe fines. What we can do is to try to get the charge either dismissed or see if the prosecutor will agree to reduce this to another charge to which we can plead guilty to, such as speeding, improper driving, or failure to obey a highway sign or some other lesser offense. We are always prepared to take the case to trial and put the prosecution to its burden of proof, in which case they'll need to produce the evidence that they have correctly measured the speed of our client's vehicle and that they can produce the calibrations or other evidence necessary to support their allegation that they have correctly measured our client's speed. The other charge we commonly defend is reckless driving under the general rule, often involving a traffic accident. And in this case, we put the Commonwealth's to its proof by requiring that they show that our client actually did operate his vehicle in a reckless manner or in a way that endangered life, limb, or property. The simple happening of an accident is not sufficient evidence of reckless driving. The court should not convict someone based on speculation or conjecture. Therefore, we often win our cases by showing the court that the prosecution has no real evidence of reckless driving, only a suspicion of reckless driving, which is of course insufficient to convict. Sorry, Sweetie, what do you think about that?
So often what we see is that the Commonwealth has not determined whether the police officer has met all the criteria necessary to convict someone of reckless driving. What we find is that in speeding cases, the officer may not have necessarily done his calibration paperwork completely and correctly. And if that happens, then we have found that to be an effective defense against a charge of reckless driving by speed. Now, in reckless driving by general cases, which is also known as endangering life, limb, or property, a lot of times a police officer may charge someone with endangering life, limb, or property under the 46.2-852 code section. What we tend to find is that is sometimes an overcharge, so to speak. An improper driving charge is sometimes charged as reckless driving general. And when we go to court, by negotiating with the prosecutor and explaining the facts around the case and the mitigating circumstances, we are able to then convince the prosecutor that the charge in and of itself is either excessive or is not necessary based on the facts of the case. How well we are able to resolve cases for our clients is certainly dependent in part on what steps the clients take to help themselves. For example, we would frequently ask clients in a reckless driving by speed case to get their speedometer calibrated. That usually helps us find potential flaws in the Commonwealth's case. Also, in a reckless driving by general case, we frequently tell our clients to attend traffic school that is approved by the DMV in Virginia. When we have our client do that, that helps us in negotiating a resolution with the Commonwealth, or in the event we take it to trial at sentencing, it helps us argue that fact at sentencing on behalf of the client. If you have been charged with reckless driving in the state of Virginia, do not hesitate to contact us. We'll be glad to help you. Also, if you've been charged with reckless driving in Virginia, take the time to understand that it is not a simple charge. It needs to be taken very seriously, and although Mr. Block stated that it's not likely jail time is going to be imposed on a lot of the reckless driving cases, it is one that carries the very definite possibility of jail time, and again, it should not be taken lightly. Thank you.